Etiefo me mo bibia kwaba eba Melodies TV so. There is a breaking news. Eba. Now it is coming from the camp of Mr Jakpa. Omo file a court document omo say case now currently kosono. The court should strike it out after allegations of Mr Jakpa ne audio eba bonteno. The lawyers no edijina so akatre judge ne say on striking it out. Now we'll go into it and understand why the lawyers are saying that. But lawyers ne kasa asem no. Omo make a very damning revelation na womo tre say Godfred Dame no katre Mr Jakpa say the entia opese wo ye na yentwa ntronto Ato Forson so ni enchi nintum ene say Ato Forson expose that time na Ato Forson wo ha oba be press conference via wo expose and na wo bo the then finance minister echi kenoforiata echi into say Mr Jakpa nsem a wo kan say Godfred Dame katre ne say the entia wo muntwa ntronto Ato Forson so no munchi nintum ne say President Akufo ene kenoforiata the pressure to wono Godfred Dame so se wonye de obetumi aye bia na wonchi Ato Forson entum enti no enti na Ato Forson sorry eno no enti na Godfred Dame opese o ya no chi Ato Forson entum no because Akufo and kenoforiata were mounting pressure say Ato Forson home adwin dodo expose bia wono no deba financial irregularities bia Ato Forson ebeba be press conference and no de sansensem ni na yankenkan and then we'll get more details into here in krata nini as a notice of application for an order striking out the charges and terminating the proceedings or alternatively staying the proceedings against the third accused. Now say please take note that this honorable court shall be moved by Titus Sorry Esquire of Mrs. Sorry at Law Counsel for and on behalf of the third accused stroke applicant herein praying the court for an order 1 striking out the charges and accordingly terminating the proceedings against the third accused stroke applicant or alternatively into a country judge no and court happen sometimes in the course of assembly amoka and assembly moody or court no say moody nsem no bo say evidence be pie and then the other party be to me aka say essence evidence we pie ninti no there's no sense was say sa case we yet so into striking it out but it will all depend on the judge into 1 or see striking it out 2 or say a stay of the proceedings before the court against the third accused stroke applicants or say and please take further notice that the grounds of the application are the Attorney General the entia wo mo ka say yen strike case no out on any or say Attorney General at whose instance the third accused stroke applicant is being prosecuted in the instant suit has brought the charges and instituted the proceedings in abuse of the process of the court and contrary to his constitutional obligations under Articles 23, 296 of the 1992 Constitution. Also, the Attorney General at whose instance the third accused stroke applicant is being prosecuted in the instant suit has brought the charges and instituted the proceedings in abuse of the Attorney General's powers contrary to his constitutional obligations under Articles 23, 883 and 296 of the 1992 Constitution. I say, in engagements with the third accused, the Attorney General has admitted that there is no case against the third accused applicants. Inti omo tremwa, sa phone conversations bebrebe also between Godfred Dame and Mr Jakpa no. Godfred Dame said in those conversations, say Mr Jakpa di ondi bone, and you know Mr Jakpa ni epesi ye chinitum. Ato Forson, sorry, and they will say ye chinitum. Inti based on sa audio no any confessions Godfred Dame aka ewo audios ni monokra no yemfenjina so yemfan strike se waka ewo audio mu se me de mindi bone umpese obechi mi atomu a de ntia na ende still me work out trese me ye third accused And court also say me a third accused there, not just me dibone. Based on that, inti yemmon semnenya den engu. It was said that the constant prosecution of the third accused stroke applicant violates the third accused stroke applicant's right to a fair trial. So let's go to the second screenshot. Or say application for an order striking. The fourth one, or say the continued prosecution of the third accused violates the third accused. Okay, we've read that. Or say upon the grounds deposed to in the accompanying affidavit, and for such further or other orders as to the court may deem meet in the circumstances. As a court to be moved on the 4th day of June, into 4th day of June, 4th June, and a case way how it will go in court. 9 o'clock in the forenoon or soon thereafter, as counsel for the third accused applicant may be heard. Dated at law, blah blah blah, goes on and goes on, goes on. Enti oha or tiaswa and for the service, the Attorney General, the first accused or his lawyers, Dr. Abdul Basit Aziz Bamba, whose address for service is only address for and all that. So basically, that is what is going on, and this should be interesting. Third accused application. Third accused stroke applicant. I say Richard Jakpa of Unnumbered House, Ashaliboche, Accra, in the Greater Accra region of the Republic of Ghana, do hereby make oath and say that I am the deponent herein and third accused in the above institute application. I depose to my instant affidavit for and on my own behalf in support of the application before the court, the fact of which, unless otherwise deposed to, being within my personal knowledge, information, and honest belief, I acquired knowledge of the fact to which I depose in my present affidavit by reason of my personal involvement and all connection with the fact on which I have instructed my lawyers to file the present application for and on my behalf, to the extent that any of my depositions in this affidavit, hints, states, relates to or states principles and or matters of law, such depositions result from the advice of my lawyers, whose service I verily believe. Indeed, this is more like an oath. What I say, indeed, the lawyers ne grata wam diabano, nensa etechwe, ni sunsum techwe. And the hearing of the application before the court, my counsel shall seek leave of the court to refer to all processes filed in relation to the matters which have provoked my present opposition, as if same were elaborately deposed to in my affidavit and incorporated herein in extents. Also, on 18th day of January 2022, I was arraigned before the court on the charge of having acted in contravention of Section 1792 of the Criminal and Other Offences Act 1960 at 29. On the 19th of March 2024, I opened my defense and started giving my testimony in chief orally, but subsequently filed a witness statement which I relied on together with my oral testimony as my evidence in chief. And so it continues to say, on the 23rd May 2024, I was being cross-examined by counsel for the first accused person on letters of credit relating to the transaction in respect of which I am being prosecuted, when the learned Attorney General interjected in the terms deposed to below and captured in the record of proceedings for that day, a copy of which I exhibit here to and mark A. The also court between Ono and Godfred Dame and I walk until say, Honorable Dame, my lady, I'm a little bit constrained to intervene because the Minister of Finance at that time was in court and justified about authorization. I wonder what Mr. Jakpa business is to testify about authorization. And I'll say after the court intervened, the learned Attorney General added, thus, just by force to defend other accused persons. And okay, in response to the learned Attorney General's allegations against me, I stated that the allegation is untrue, and I did so in the terms captured in Exhibit A, set out below. Mr. Jakpa, my lady, I want to put on record that I am not here to defend accused person 1. I have not told you that you have defended accused person 1. And Mr. Jakpa said, no, I am not talking about you. And I say, who says so? I say, the Attorney General did. The Attorney General did that. He accused me directly, and I want to respond. So that is more like, let's continue with the other pages of. Inti, send American and somewhere course or court no. And no. I say, after the proceedings for the day, I had a conference with my lawyers who demanded a full explanation from me about the statement I made in connection with my engagement with the learned Attorney General in court. So see, a course or court on only Godfred Dame, a course we no. And after the lawyers inti answer na assembly because none the lawyers screen him the AC. And after the lawyers be catch say, hey, then they only Godfred Dame somewhere course or court in same na now can say ube be Pandora box no. Trechen in same nimu. And I say after my release on bail on the terms fixed by the court, I met Honorable Godfred Dame, the Attorney General, in the early part of the year 2022 and explained to him the background and nature of the transaction on which the prosecution against me was mounted. After listening to me, Honorable Dame assured me that he now appreciated the facts and issues relating to the transaction and indicated to me that in law, agents are not liable for the acts of their principals. Into what I feel a word train same mu ye say and so now we a court in Krata. So Mr. Jakpa Sembia Wobeka ewo court biano, it is taken as the truth until proven otherwise. Into a tremu say 2022 ena Godfred Dame ye man bail wie no eno koko shia Godfred Dame. O shia Godfred Dame no church nsemu etre Godfred Dame e ho na Godfred Dame ka say oh no kware o de na nka boni bia ni wo asem ho. Well, see, he further explained to me that based on his understanding of the contract, the court was likely to accuse me at the submission of no case stage because he was not going to oppose it, adding that, as a matter of fact, Dr. Sylvester Animana, the second accused, and myself, the third accused, were just added as accused persons in order to mask the real target of the prosecution, which is the first accused. So see how when I go for Dame and say, oh, now assembly crano, and you wona ye di with you. One second accused, Mr. Animanano, and you muni ye di mochi. Ya sheda ni edemo kan ba nipa kra pese ye chi ni tumpan no ato forcing. But ye ya na say ye ne ye chi ato forcing pa to mo a Ghana fo be hu ne say da be MPP for ye trimo den. Inti ya sheda ne edewo ene Sylvester Animana second accused no aka ho. But at the end of the day, ye we are ye be jai mumu ne ya chi ato forcing pe atum. Se NDC for kan ne aka se wo. Se anya ato forcing pe ne de ne court. Na so sense onu no di bone no. Inti na ya chi ono pe atum no. So see, Honorable Dame also explained to me that the first accused prosecution had to be undertaken because of pressure. Or see, the first accused prosecution had to be undertaken because of pressure from the former Minister for Finance, Dr. Ofori, and the President, and assured me repeatedly that I was not the target of the prosecution. See, clearly, no, or see, Godfred Dame catch and say, pressure Ofori any Akufo Dame man ntia no person ochi Ato Forson-Tum. Ofori any Akufo Dame man pressure so one chi Ato Forson-Entum. If indeed that is true, for those who are wondering, say the presidency has said nothing about Godfred Dame ni tape no, then also who they say somano there's nothing President Akufo will do to him. Basically, Obi baby say, then why is it that the MPP no or mu defend the assembly, sir? Now you have your answer. So according to Mr. Jakpa, no, Godfred Dame catching say, Ofori ni Akufo do na man pressure say, onye no nche Ato Forson-Entum. Na Ato Forson home. This is serious. Hey, Charlie. The mafia. Hey, proper mafia. Also, based on the interaction I had with Honorable Dame, a relationship of trust developed between us because I believed him since as a lawyer and the person who initiated the prosecution. He assured me that as an agent, I am not in law liable for my principal's actions. Very well aware that I now trusted him, Honorable Dame told me that he was informed that during the investigations, I had made some documents available to the Economic and Organized Crime Office and asked if I could share more of them with him, and I promptly did by forwarding some relevant documents to aid my case to him from my cell phone. I say my first hunch that Honorable Dame may be abusing the trust I reposed in him came when, after assuring me that an agent is not liable for the act of his principal, he, the Attorney General, filed a submission contesting my submission of no case. Inti ose ono de one Godfred Dame building relationship. Now one Godfred Dame inti akwa say, you see, and this even shows say Mr Jakpa no ase and yes, Godfred Dame say or ye move ewo ne chia na ke bi ono kra on ba bonte me kan same way. Because ose one Godfred Dame building relationship. Emo mo bedane down for ena de bia wo hia no ma discuss case no. Nti Godfred Dame ka tell ne say wo de enye wo na ye ba be chew. Ye be che Ato Forson. Inti wo bo amani enche Ato Forson ye den entum. Inti oye na je se na nka sa obeboa. But the man necessary na adwene ne say obi a wo ka se me there's no case on me. Na me de me mfa ho no. Me mekwa file for submission of no case. Not just say or no file say case no. Me no mindi bone. So say amra wo file say won di bone no. Godfred Dame ko contest sa submission no. Nti e ho no fan ne ho adwen say no obi ade bia oni mi hia wo ka se me de mindi bone na me de obema ye jame na afemi amakwa file wo court say ye nyan me ma share information ne nyama ma me boa na ma amakwa file wo court say ye nyan me a wo Godfred Dame wo ba be kon ade no ama afa ye nyan me na tre say wo daada me na tre say nsem a wo kan tre me no wo twa me ntro na tre say tiefo ade no na ka Godfred Dame ankwa file ankwa contesti Mr Jakpa ne submission of no case krana na ka ebi krana nko no kra nko be boa Godfred Dame ni ache Ato Forson atum. It was said the court upheld the Attorney General's contention that a case had been made against me to answer, and when at subsequent meetings I expressed my disappointment at the turn of events, he resumed his assurances to me and then started to solicit my cooperation, first to testify in a manner to incriminate the first accused, and secondly, to help fast-track the conclusion of the case by first week of May 2024, which is also the reason why he discontinued the proceedings against the second accused by filing a nolli prosequa. It was say, Godfred Dame ekuntia no wieye, Godfred Dame winning case no. Eno sanso ko share Godfred Dame na afei wakatren say Godfred wanya de. No bia de bia me share wa meboa wo. Wo ka kire me say senior case ne kono me de mindi bone nti ebegya me mu. Na afei man amakwa file e wo court say yenya me mu a. O ne me aba be ko ama court aka say man yenya me mu. Ase wo ya dada me. Eno say Godfred Dame ka kire say wo dabi me ndada o. Ato Forson na me pese ye chini tum na eno na me pese ye. Eno na me pese ye. Sisi ade de me pede nti amako etia wo ne say me pese wo ho na wo testify won o dane because on a case no wom nti se wo ba betwa ntro eto Ato Forson so e wo court beji wedi nti de nti amako etia on say because man ko etia on sisi ana untumi e ma betwa ntro nto Ato Forson so e ma me e wo court ho nti me pese sisi ano oba na ba betwa ntro to Ato Forson so e kire me e wo court ho so ba betwa ntro to ne so a ne ya ye ne ache na tum na afi no mama ye JAIL. It was say asked why he would not file a nolli prosequa in respect of my prosecution, as he did with the second accused. Honorable Dame answered that it would then leave only the first accused, which will make it even more obvious that the first accused is the target of the prosecution. Inti ehwano, the second accused no Godfred Dame be JAIL case no HED. Once there 3 people ni accuse yomo. Ato Forson, Mr. Sylvester Animena, ena ono Jakpa no. Inti Godfred Dame be JAIL Animena no asem emano. Ena ebeka Ato Forson ena ono Jakpa no. Nti we no bisa say inti de ntia na Animena no no de we JAIL ni mu a me no still opese oso me no se odabi se wo de me JAIL mu a afi de be ye clear wo bia be hu ne se wo ye politics ena ye pese ye de chi Ato Forson atum eno hu nti no etie for ensem hey and you see send America no we mu ni na ye court document it aba be dane evidence Mr Jakpa nsem we ya wo kan na no untumi nka say yentro until proven otherwise, because once a court no you swear by oath. So once you swear by oath, every single thing you are saying, it means it has happened. It is seen as the truth until proven otherwise. It is in that Mr Jakpa can't say when in our court not say no quarry until say Godfred Dame beba be prove say no quarry. No Godfred Dame to me be prove say no quarry. Mr Jakpa no can be to me action for perjury because we can't throw in court documents. So this should be interesting. Or see, in any event, as I have always explained, the nature of the transaction to the learned Attorney General based on the relevant documents, even though I always had a lawyer representing me in court, I told him during several meetings with him that I was unable to testify in the manner suggested by him so as to incriminate the first accused, because such testimony would be betrayed by the documents in evidence and in any event would not be honest. Or say the discussion about my testimony after I opened my defense culminated in a phone call to me on the 9th April 2024 by the learned Attorney General when I was to appear in court to continue my evidence in chief in terms of the witness statement I filed. The matters I have testified about and also the discussions I had during Honorable Dame's call to me are available by way of the WhatsApp conversations on my cell phone and also a recording of the telephone conversation, which I am prepared to make them available to the court and be cross-examined on them. So what I say, our evidence, a WhatsApp between Onone Godfred Dame, any phone recordings. Ono ebe serving as evidence our court. Na Godfred Dame pa, yema kwa no mrambe cross-examination. Or you're ready for cross-examination. In the phone conversation between Honorable Dame and me, he suggested that during cross-examination, I testified not based on matters personally perceived and understood by me, but based on his suggestions. In the telephone conversation, the Attorney General is heard directly engaging me on the subject of the LCs, which before his interjection were the focus of the first accused counsel cross-examination, and stated how he thought I should answer questions regarding the LCs during cross-examination. I repeat paragraph 26 of my affidavit and depose further that when I disagreed with him, the Attorney General suggested that he would be traveling and not be able to be in court at the next adjourned date, and that I seek an adjournment from court by informing the court that I was sick to allow him to be present in court. Before I proceed with my testimony, I declined this suggestion. It has become clear to me without a shred of doubt that the charges against me in the instant proceedings are only being pursued by the Attorney General against me in abuse of court process, as they are not pursued bona fide. Abuse of his prosecutorial powers, which must be exercised not only in accordance with law, but also fairly and reasonably in good faith, without arbitrariness or caprice. In abuse of my right to a fair trial, because my interactions with Attorney General and my openness to him by virtue of the trust I reposed in him as a lawyer. Therefore, case no, baba beyede. MPP for afei ababe dane court documents. The MPP for defense our mama Godfred Dame nana. This is when they get exposed. We wait. Don't try to comment box anymore. But that's it.